We're going to talk about capacity and genuine assent. Contractual capacity and genuine assent are additional elements to a contract. In addition to the offer and the acceptance, parties have to understand they're entering into a contract and there has to be a true agreement. In other words, you have to have contractual capacity and you have to have genuine assent or true agreement to the terms. So these are additional elements. Contractual capacity does not mean that you can understand every term. It just means that you understand that you're entering into a contract. It does not include the full legal meaning of a contract. And everybody, as a general rule, is presumed to have contractual capacity unless there is a status of incapacity. And a status of incapacity could be, or an example of status incapacity is with a minor. Minors are the category that there's status incapacity, or this class is generally considered to lack contractual capacity. There are some exceptions to the rules. There's also factual incapacity. And under the circumstances of factual incapacity, it is not based on a whole class, but it depends on the facts and circumstances. Factual incapacity exists when you have medical condition, or medication or drugs or alcohol or illness. And under the circumstances, because of these things, the person lacks contractual capacity, but it's based on the facts of the or circumstances of the case. Minors, for the most part, can disaffirm, avoid, or set aside or get out of a contract. A party who makes a contract at the time they make the contract, they're under the age of 18, is considered to be a minor. A minor can disaffirm or void a contract, and as a general rule, all they have to do is give back what they have. So if the property is damaged, give back whatever is damaged. If there's no property left, then they still can disaffirm as a general rule, and they have until a reasonable period of time after reaching majority, which is 18. So doesn't cut off just at 18 in order to disaffirm the contract. So contracts that minors make are considered to be voidable as a general rule at the option of the minor. If a minor misrepresents their age, there are three different views. Some states say that the minor can still avoid or disaffirm the contract. Some states say the minor cannot disaffirm or avoid the contract. And some states say the minor can avoid or disaffirm the contract, but they are responsible for damages. If an adult deals with the minor who's misrepresented their age, the adult can get out of the contract based on fraud, not because of the minor's age, but because it constitutes fraud. Again, the restitution by a minor, just give back whatever you have. If it's damaged, the minor, unless there's misrepresentation of the age and you're in a state that follows that rule, is not required to, as a general rule, if there's damage to the property, the minor is not required to pay for the damage. They just return what they do have. A minor can disaffirm necessary but must pay the reasonable value. Necessary is considered to be food, clothing, shelter. Also, it includes health care and also education. The minor does not have to disaffirm the contract. The minor may affirm or ratify the contract by performing the contract, expressly approving the contract, or by allowing a reasonable period of time after reaching majority to lapse. The minor cannot disaffirm a contract that has been ratified after the minor has reached the age of majority. Contracts that cannot be disaffirmed by minors vary by states, but they can include educational loans, contracts for medical care, contracts made while running a business, contracts approved by the court, contracts made in performance of a legal duty, and contracts related to bank accounts. Ordinarily, a parent is not liable on a contract made by a minor. When a minor makes a contract with a co-signer, the co-signer will remain liable under the contract even after the minor avoids the contract. If a person is mentally incompetent at the time that they make the contract, such that they don't understand they enter into a contract or they're entering into a contract, then the contract is considered to be voidable at the option of the mentally incompetent person. Upon becoming competent, that person can ratify or affirm the contract. If a guardian has been appointed by the court, then the only person who should be making the contracts, if a person has a guardian and they've been adjudged to be incompetent, then only the guardian should be making the contracts. So any contract made by an incompetent person without their guardian, when a guardian has been appointed, is void, not voidable. But if no guardian has been appointed, the contract is considered to be voidable at the option of the mentally incompetent person if the person made the contract while they were incompetent. Intoxicated persons, if a person is so intoxicated they don't understand they're entering into a contract, they can disaffirm or get out of the contract. And this includes intoxication by alcohol and also drugs. A unilateral mistake is a mistake by only one party. A unilateral mistake, if the other party is aware of the unilateral mistake, then the party who was aware of it, if they are aware of or should have been aware of it, then you can disaffirm the contract because it's a unilateral mistake. But usually you cannot disaffirm a contract based on a one-sided mistake. A mutual mistake, where both parties have made a mistake, the contract can be disaffirmed on that basis. Another type of mistake is when parties make an oral agreement and when the agreement is recorded and something is left out. Reformation by a court is possible under these circumstances here. Fraud is the making of a material misrepresentation of fact. If you have fraud, there's no true agreement. It means the genuine assent is lacking. In order to have fraud, you have to have knowledge of the false statement that is made. A false statement has to be made, knowledge of the false statement, or reckless indifference as to the truth. Somebody has a duty to know that the statement is false and doesn't check. The person listening to the false statement believes it's true and relies on it. And then the person who thought the false statement was true, some harm results. If you have all of those elements, fraud has been committed, and the fraud means that the person upon whom the fraud has been committed is the contract will be voidable at that option of that person. Ordinarily, statements of opinion or value are not fraud. Usually, you're talking about a material misrepresentation of fact.